Hi, my name is David P. Shapiro. I'm the owner and managing partner of the law office of David P. Shapiro, located in San Diego, California, where my firm helps good people regain control of their future when charged with a crime. In this video, I want to talk to you about some defenses to sexual battery charges in San Diego. The most obvious sexual battery defense is, it didn't happen. I didn't do it. And that's what we see a lot of times, where someone's accused of having a contact with another human being that person did not want, and it's accused that it was of sexual nature. And the best defense may very well be, hey, it didn't happen. I didn't do it, or it wasn't me. And that's stuff that requires, though, that you not speak to your accuser when you're confronted about it on a phone call, via text message. And a lot of times requires that you not really speak to law enforcement either, because a lot of times you'll say things and they'll get you to say things that'll corroborate at least something of what the accuser is saying, and it may very well blow up your best defense should the case proceed to court, certainly should it proceed to trial. Other times, though, a really strong defense is the defense of consent or mistaken belief of consent. Okay, so the defense would be, yes, we did have that contact, but either the accuser did consent at the time, or I had a reasonable good faith belief that the individual accusing me now of sexually battering them did consent at the time, whether they did or not. And that's really a unique defense here, because if the belief is reasonable, even if the accuser is like, no way, I definitely did not consent, you can and still should be acquitted at trial if a jury believes that it was at least a reasonable belief that you could have had. And what are you allowed to introduce? Well, you're allowed to introduce a lot of the totality of circumstances about what made you believe that, and would someone who knew what you knew acted that way, and would acting that way be reasonable, even if it wasn't necessarily the way that a juror would do or handle the situation, even if it's different than how the district attorney may handle that situation, even if it's different than how your defense attorney may handle that situation. So just because you're charged with sexual battery, just because there was some sexual contact, does not necessarily mean you do not have defenses. You certainly have plenty. And even if what you're accused of doing did actually happen, if you had a good faith, reasonable belief that there was consent, then you have a viable defense, and a strong one at that. But you need to do your part in not discussing the case with law enforcement, not discussing the case with your accuser, not discussing the case on social media, and making sure you discuss the case with a quality, locally experienced criminal defense law firm who has a track record of success dealing with sexual assault allegations, who handles these cases day in, day out, in the courthouse, in the courtroom in many instances, where your case will ultimately have the majority of its hearings. We are one of those firms. We are just a phone call away, 619-295-3555.